from a man caught with drugs and violating probation.
That's the problem. So I don't think I should continue you because you haven't done anything. In this court, my thing is, if you have a drug problem and you think you're going to use, pick up the phone, call probation, but you didn't do any of those things.
To another facing charges for criminal mischief.
Proceeding on the lesser included criminal mischief greater than $750 but less than $2,500.
These cases shows how Judge Boyd ensures offenders are held accountable, starting with Mr. Salinas, a repeat offender facing charges for dealing on drugs and repeatedly violating probation.
A court is calling 2018 CR 1071 State versus Christopher Salinas. Could I have parties announced for the record for the state?
Salinas, Megan Galloway for the state.
For the defense?
Robert Featherston representing Mr. Salinas.
And are you Mr. Salinas? Mr. Salinas, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Christopher Salinas who's placed on deferred adjudication in 2018 CR 1071 for the offense of possession with intent to deliver a controlled substance, penalty group 2, 4 to 400 grams, on July 6, 2018 for a period of 5 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Christopher Salinas, did then and there fail to report to the supervision officer as directed for the months of May, June, August, October, and November of 2024 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State.
We leave and abandon the remainder. Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor, based on the allegation that was pled true to, the state is asking for 5 years to use.
All right. Defense. I mean, the rank, that's the minimum.
Yes, Your Honor, and we're not in agreement on that.
All right. What are you requesting, counsel?
Your Honor, the court needs to be aware that in April of 2023, Mr. Salinas went into the hospital to have L3 and L5 on his spine repaired. He remained in the hospital for 3.5 months and then was released. Since that time, he's been in constant chronic pain from the spinal repair. His chronic pain, Judge, has led to his continued drug abuse that led to his failures to report. It's led to his failures to provide samples for urinalysis. He recognizes that he has a drug addiction problem because of his chronic pain, and that has not been alleviated. He's been unable to work. He can't stand for long periods of time. These are contributing factors to his failure to report in 2024 to his probation officer. He's not committed any new crimes that have been alleged in the MTR. Probation is recommending substance abuse treatment facility. We would like the court to consider that recommendation of substance abuse treatment facility. Mr. Salinas would like to go to SallTheMan and successfully complete that in hopes of getting control over his chronic pain and then getting the appropriate prescriptions subsequent to be able to handle his pain. And then we're respectfully requesting that the court consider an 18-month extension as recommended by probation in order to be able to accomplish these goals. And I thank the court.
Thank you. All right, Mr. Salinas, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Christopher Salinas.
All right, so your attorney said that you were in the hospital, and I'm taking that as true, counsel.
Thank you, Your Honor.
So My question is, you were in the hospital April 2023, and you were there for 3 months. So
Oh.
that means May 2023, June 23, July 23, and I'm gonna even give you August 2023.
I was actually, after that, I went to physical therapy for a month.
Okay. No, I'm giving
Oh,
you,
okay.
I'm giving you 4 months after that.
Yes,
So you're in hospital April 2023, and I'm giving you till September. I'm not even gonna consider you're not reporting September 2023 from April 23 to September 2023. So October, did you call probation?
yes. They-
No. Here's the thing.
Okay.
Did you pick up the phone and tell them, I'm going through some problems and I cannot report?
No.
All right. Have you done anything on probation?
Yes, I've done some community service. I mean, I did about 12 hours
Okay.
recently. And
All right, so that's 12 hours. You were placed on probation with a previous judge since 2018.
right,
And from 2018 to now, you're telling me you've only done 12 hours of community service restitution?
24 total.
All right, 24 hours since 2018.
Yes,
And you were actually in court with me on January 17, 2023. A previous motion to revoke had been filed, and it was withdrawn for your conditions to be altered and amended. And those conditions from January 17, 2023 was to do 90 sober meetings in 90 days. You were supposed to be residing with your mother. Did you continue to reside with your mom?
yes, I still live with my mom.
All right, and then you were supposed to do the UA hotline until further notice. And you're supposed to be doing intensive outpatient treatment. There was supposed to be regular reporting by Zoom or in person, so you didn't even have to go in person. You could have done it by Zoom. And there were to be field visits 2 times per month and partial GPS for work. And then you were allowed to run errands or whatever you need to do on Saturday and Sunday from 8 a.m. to 5 p.m. And you haven't done anything. That's the problem. So I don't think I should continue you because you haven't done anything. And in this court, what do I always say? If you have an issue, pick up the phone, call probation. If you feel they're not addressing it, you can always come to court. And I know that I would have told you, if you have a drug problem, in this court, my thing is, if you have a drug problem and you think you're going to use, pick up the phone, call probation. I'm not looking to revoke people because they have a drug problem they're about to use. I'm looking to try to get you help so you won't use. But you didn't do any of those things. And you've been extended before. And the fact that you've been extended before, that means that there've been problems before. Otherwise, nobody would have extended you. And so you've been on probation since 2018 and you really have done nothing. So I'm not going to continue you.
Yes,
Yes.
man, from 2018, I completed all my programs that I was supposed to complete. And the reason why, I mean,
You told me the only thing you had done was community service hours.
before that, that's when when we came back the first time.
Did you do your 90 sober meetings in 90 days?
I've done meetings. I have.
Now, did you do your 90?
Completed. No.
All right. I just don't think you're a good candidate for probation. And let me explain to you, one, I'm finding it true based upon your plea of true, but here's the thing. You have to at least try. There's nothing I can do if people don't try. And I can't continue to give chance after chance when people don't try. I mean, the only other thing left for probation to do is to come to your house, give you a ride to their location, or either come to your house and sit down with you and bring somebody to, have the classes come into your home, and they don't have the finances for that.
Your Honor, may I address the court?
Yes.
Judge, everything that you say is quite logical about what should be done on a community supervision program. Here, for Mr. Salinas, there is this extenuating circumstance with respect to his back
Mhm.
problems. A very extensive stay in the hospital. It's quite uncommon to hear of a 3.5 month stay in a hospital for anything nowadays. So there was something significant there. And quite frankly, I'm not a medical doctor, and I don't really know much about L3 and L5 in your spot.
Oh, no, I appreciate what you're saying, that for them to keep you in the hospital for 3 months, it is extensive.
And the court's explanations with respect to 2024, because this is in 2023,
Mhm.
with 2024 is quite valid. But this is a gentleman that found himself, he's out now of the hospital. He doesn't have a job, he doesn't have insurance. He's got chronic pain. He needs medication for that. So he goes to controlled substances for medication of that. And now the fear factor for going to probation is through the roof, because he knows if he goes to probation, he knows he's going to have to give a sample. And he's unsure as to whether probation is going to consider his chronic back pain as an adequate explanation. And I understand his fears are valid in that respect. If it wasn't for his back surgery, Judge, I would have no leg to stand on with respect to revocation.
Mhm.
I'm asking the court for its mercy here with respect to Mr. Salinas, and allow him to complete an inpatient drug treatment program, and then allow him to go ahead and complete his community supervision program. I thank the court for its time.
All right, thank you. And I want you to know, I heard your counsel's argument, and I think it's a very good argument. But the issue is 2023. Here we are in 2025.
Yeah.
Yes,
Thing is, I had a surgery in my lower lumbar, disc 5 and disc 3. I didn't get it repaired. They had to shave it off. So it's very fragile.
no, I understand it's fragile, but here's the thing. You didn't even pick up the phone to call probation.
My probation has the copies of all my medical records. They
No,
know
did you pick up the phone and call probation? Because let me explain something to you. The allegations in the motion are that you didn't report for May, June, August, October, and November of 2024. What that means is you didn't go to their office, you didn't call them, you didn't do any of that.
June, July, August, September.
I mean, you played true
I
to June, August, October, and November 2024, and May of 2024. You played true to that of not reporting.
I've seen my probation all the way up to September. October is when I stopped. Since from there to there, I have reported.
All right, so this is,
That's a misunderstanding.
Okay.
Okay, so since October and on is when I stopped reporting. Before that, I've talked to probation officers. I've been to the
Right, so
office.
here's the
everything.
thing. I don't know why you stopped reporting in October. All you had to do was pick up the phone. Right? And you know, because you've been before me before, you know that if there's an issue with probation, let the court know. You know, if there's an issue where you think you're going to use, or you have a drug problem and you're feeling weak with drug use. That's why I did the 90 sober meetings. And that's why I said, if there's an issue, let probation know, and then we will address it. Your counsel can tell you normally, unless there's something else going on, if somebody has a drug problem and they're actually trying to maintain their sobriety, I normally don't revoke for that. Right? So the court is finding violation of condition number 5 true. The court will find you guilty. The court is going to grant the motion, sentence you to 5 years in prison. That's the minimum. And I'm doing the minimum because, one, the state requested it, and also considering your health issues. Give you credit for any time served. I'll recommend the therapeutic community and counsel. I'll retain jurisdiction. I'm not sure if he qualifies for that because I don't have his history before me, but if he does, I'll retain jurisdiction.
Thank you, Your Honor. And if the court would entertain a suggestion, because of his back issues, with the court consider a full house arrest at his house.
No, I will not do that. but I appreciate your asking.
Thank you, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Are you sentencing the 5 years TDC?
Yes.
Yes. I have never even been in trouble.
All right,
Since from 2018, this is the only reason why I'm keep coming back from failure. I've never gotten a new case or anything. Your Honor, please.
all right.
I'm
So
done.
did you review the Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, I understand what you're saying. There are many people that come before me, guess what? They've never been in trouble before. This is their first case and it's a felony. But by that same token, do you know how many people who have never had a case, they're not on probation? I mean, I can only help you with your probation if you show up. Otherwise, I can't help you. All right, the court is calling Tommy Lopez.
Unlike in Mr. Salinas' case, here we have Mr. McIntyre facing a high felony charge tied to a deadly shooting, yet his trial drags on due to missing evidence.
It's calling, everyone needs to be quiet. Court is calling 2019 CR 12495, State versus Tamar McIntyre. Can I have parties announced for the record for the state,
Jason Gary, Your Honor.
for the defense?
John Hunter for Mr. McIntyre, Your Honor. I believe that
Where is he?
Mr. Goldstein is.
Yes, he is.
appearing by
He's here.
Zoom.
Good morning, Your Honor.
Good morning. All right, this is scheduled for jury selection on Friday. Why are you all here? What motions do you have?
The state filed just a motion in limine, Your Honor, just for a few things. I don't know. It was filed this morning, so I don't know if defense has had an opportunity to view it.
I've not received service of it, Your Honor.
Alright.
Mr. Goldstein advised me just by telephone about 2 minutes ago that he saw that it had been filed, but I don't believe he's read it either.
All right, so
I
with
was
regards,
unable to open it, Your Honor. My apologies.
no problem. With regards to motions and limines, I do not know anything about this case. So as far as me ruling on any motion and limines, unless it's something that's specifically in case law where it's not allowed, then of course the court will make its ruling. But if it has to do with whether or not certain questions should be asked or whether or not certain evidence should be presented, y'all will need to approach prior to going into whatever subject matter you have with regards to motion and limines from the defense or from the state.
And Judge, it's not something associated with voir dire, it'd be associated with the actual case in chief and punishment. So it's not a question of hearing it before we pick a jury.
All right. Any other-
Your Honor, if I may, I'm particularly concerned about a recent disclosure that the state's key witness has given prior sworn testimony before a previous judge in this court regarding our client's participation in this case. And I believe I would like to make sure that we're able to supplement our motion for continuance with state versus.
Just 1 second. Let me finish addressing the state. Are there any other motions?
Not at this moment, no, Your Honor.
All right, defense, any motions?
Your Honor, we have filed a motion for continuance back on January 24th, and I informally had advised the court of the fact that that was a concern. Let me update the court since then, because there will be need for us to supplement.
All right, and
because of its
before
verification.
everybody updates me on the supplemental as it relates to the motion for continuance, let me ask everybody a question. Did I not ask you all what date you all wanted for jury trial? I had given everybody continuances before. People wanted to go on vacation or trips with their family members. I let them go. I said, talk to the coordinator and choose a jury trial date. Is my memory faulty or is that what I did?
Your Honor, let me, if I could give.
Well, no, we're gonna get to that. But did I do that?
Yes, sir.
Yes, Your Honor.
Did you all choose this date as your jury trial date?
Yes, sir.
Did
Yes.
you all choose Friday as the date for jury selection?
Yeah, yes, sir.
All right, and then today was supposed to be for motions. And this was done, I think, back in November. So before I get into your motion for continuance, because I want the record to be clear, this case has been on the court's docket since 2023. We are now in 2025. So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. Then it was recalled on December 7th, 2023 for discovery. Then it was called on January 30th, 2024 for discovery. Then it was set for jury trial, and it did not go to jury trial because there was more discovery. So then we came back on April 2nd, 2024, and it was set for jury trial for October 14th, 2024. Then everybody said, we can't do that. We have vacation, we have this. Then we came back on September 19th. I'm sorry, we were here on April 2nd, 2024. Then we came back on August 27th, 2024. Then it was recalled for September 19th, 2024. Then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then we had the jury trial scheduled for October 14th, 2024. Then we came back on November 21st, 2024, discovery acknowledgement sign. And then we came back on December 2nd, 2024. I told both parties I wouldn't charge a continuance to either side. Then we came back, and here we are. So I'd like the record to be clear on what is happening in the case. So now I'll hear your motion for continuance.
Yes, Your Honor. With respect to the court's recitation of the history, I think it's important that we make clear the settings that were held in September of 2024. We had every reason to believe when they were being discussed in the spring of 2024 would hold based upon the production that the defense had already received and based upon the state's representation that apart from jail correspondence, which was of little evidentiary value in the case, no additional discovery would be forthcoming. In July of 2024, the defense, in getting ready for that trial setting and making preparations, found a one-line entry on one page of what is otherwise a very extensive and copious amount of paper discovery, referencing a remark by a detective that he wished that he could also have in his possession ballistics reports done on a firearm that was recovered from Jalen Bell, who is an indicted co-defendant in the case, who has already pleaded guilty and been sentenced to prison. We, based on the discovery, came to the conclusion that no such firearm had ever been tested, and that its origin, or its location at that given moment was unknown. We began conferring with Jason Garahan for the state about this matter, and we tried to bring this matter to the court's attention. Mr. Garahan engaged.
Wait a minute. Let me stop you right there. What do you mean you tried to bring it to the court's attention?
We informally approached the court, I believe, on a couple of different occasions to advise that this was a matter of concern, and then eventually we filed
Are you talking about
motions.
when you filed the motion for continuance?
The original motion for continuance was not the first time that we had made the court aware of the issue, is what I'm trying to divert to. We were concerned almost immediately in late July, early August of 2024 that this was going to be a matter of concern, and we were trying to get to the bottom of what was going on.
But you all picked the court date
Well, Your Honor,
for the jury trial.
yes, and as I'm explaining, that court date was selected sometime long ago. In the course of preparation for that, we found a very, very, very small reference to this firearm in what is otherwise a very, very large amount of evidence. We advised the prosecution of that fact and sent over a draft motion to compel about anything that was related to it. But of course, we didn't need to file or urge the motion to compel because Mr. Garahan, who has been doing an excellent job keeping up with this, was similarly, I believe, and correct me if I'm wrong, not really aware of the firearm recovered from Jalen Bell because previously it had had such little significance.
So you didn't file a motion with the court urging the court to compel any evidence, correct?
We approached the court and advised the court of the fact that we were trying to sort out this discovery matter between the parties, which we did. We sent a draft motion to compel over to the prosecutor, and rather than having to urge it formally to get an order for the production, the prosecutor undertook his own independent steps to locate that firearm.
All right,
That
so
fire-
I'm just trying to get the record to be clear, because I like for the record to be clear.
I'm doing my.
Nothing was urged with the court. No motions were given to the court about any other evidence, correct?
Well, in September, Your Honor, I believe we did urge a reset or a continuance based upon this information. But I'm just giving the backstory to the time when we formally discussed resetting the case because of it was not the first time that we had brought it to the court's attention that we were concerned it might cause delays in the process. And I'm further just trying to explain that this wasn't evidence that the prosecutor just had in hand and it was in his file and he just hadn't given it to us. It was information that Mr. Garahan similarly did not have anything more than we did about it at the time that we corresponded. Now, law enforcement involved in the case may have, but it hadn't made its way over to the DA's office with the rest of the discovery.
So that's September, October, November, December,
I'm not quite-
January?
I'm not quite done with the recitation, Your Honor. I do want the record to be clear.
Sure.
So we advised Mr. Garahan of this throughout August and September. Efforts were made to locate this. The prosecutor advised that they had identified the firearm that we were discussing, and they sent it over for ballistics testing. That ballistics testing came at the end of September in accordance with when the court reset this matter for this issue. We engaged an expert witness at Huskey to conduct his own independent analysis of the firearm. Mr. Huskey advised he would not need a laboratory of his own to conduct that analysis, that he could work off of the bench notes from the firearms investigator for the state of Texas. My records indicate that we engaged Mr. Huskey formally on the 10th of October, but we would have been in discussions with him the week prior. We have sent Mr. Huskey, we believe, everything that he needs to complete his analysis, but Mr. Huskey has advised that he has not finished his analysis. This was the major pressing concern of the remaining settings of the fall, is that we did not have the ballistics analysis. And we believe that this is an extremely material piece of evidence because it goes to the heart of the state's case, which is that Mr. McIntyre was the shooter in this engagement, and that there are at least, there are 4 other individuals in the car besides the deceased. So, and the deceased, just to give a brief summary of the facts, the police that have investigated this have averred that the deceased was ejected from the vehicle or forced out of the vehicle, that he jumped back onto the hood of the vehicle, and that they allege Mr. McIntyre discharged a firearm and killed him. So if, in fact, that firearm that was in the possession of Jalen Bell were to be identified as the firearm, or if it could not be ruled out as the firearm, that would be a material aspect of Mr. McIntyre's defense, and an essential one. So that explains the general landscape. Yes, along the way, there were discussions about scheduling conflicts, some of them of a personal nature with some of the litigants. But the primary thrust and reason why we have been resetting this matter time and again since September has been out of concern for the fact that the defense has been unable to independently.
No, this has been reset since May of 2023.
Yes, Your Honor. And I'm just explaining, we did not discover this information until the time frame that I am letting the court know about. We discovered it at the end of July. Throughout the course of August, we were conferring with the prosecution. In September, we had discussions at the bench about this matter on the record, in which it was established that we needed this information, that it was material. The court granted the continuance on that basis. The state was able to produce for us a ballistics report for this firearm. That ballistics report required us to have to go and independently vet whether the report was accurate or if there were any reasons that we might be able to cross-examine the author of the report based upon his analysis. And that's what we have been working very diligently to try and accomplish, but we don't have that report yet. In the interim period, at this court's last setting in December, the court asked if discovery had otherwise been fully complied with, and we believe it had, apart from this continuing issue that we've experienced regarding Mr. McIntyre's jail correspondence, which we've now discovered the reason why we've been unable to download that material is because an associate in Mr. Goldstein's office, who's only made one filing in the entire case, has mistakenly been placed on the clerk's list as the lead counsel. And as a result of that, neither I nor Mr. Goldstein were able to access from our credentials that e-discovery. However, Mr. Garahan has been extremely helpful with us because the state didn't realize why we weren't getting the discovery either until just a couple of weeks ago. And we have been going over and meticulously getting this information on external hard drives and handed over to us so that we can process it. It's voluminous, but it is largely not relevant to the litigation. At that setting, the court asked of the state of Texas whether or not it had fully complied with Article 3914, and both parties represented that we believe that it had. Since that time period and since the first of this year, and we've
Just 1 second, let me go back to this expert. According to our last hearing on October 10th, 2024, the information I received from both parties was this. I said neither side would be charged with a continuance. State was unable to have some witness appear because of the county budget. You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor,
Yeah,
because
well,
our
well, just-
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
That's what I'm explaining, is that by October 10th, I mean, so we discovered there was a problem in end of July, beginning of August. Throughout August, we were looking for a gun. By the September settings, we were aware that there was a gun.
Yes.
And then the state produced a report. On the 10th was the date that we had engaged formally Mr. Huskey, having conferred with him informally for a week prior. We weren't even sure if we would be designating him as an expert at that time. We, at the time that we had that bench conference, assumed, not being firearms experts ourselves, that it would require Mr. Huskey to have access to the physical weapon and to the laboratory analysis. Mr. Huskey has advised us, and I believe that this is consistent with what I've later learned talking to other people in the field, that it is very common in the industry of firearms and tool mark examination for the examiner to be able to run a preliminary round of review and critique of the methodology and the reliability of the data based solely on the bench notes and the work product of the original firearms investigator, and that we would not need access to a laboratory. That led me to have an overinflated sense of how quickly we might be able to get it done if it was simply a matter of paper review. But it has turned out that that doesn't seem to be the case, and Mr. Huskey has not, as of today's date, given me a final report that I would be able to make use of. In fact, I'm having to essentially designate him somewhat prematurely because I don't have an opinion upon which I can confidently say that I would choose.
Have you called him to ask him when
Multiple
he's
times.
available?
Multiple
Well,
times.
what's the answer?
Well, he's physically available for the trial, but he doesn't have any
When will he
analysis.
have analysis done?
He hasn't given me a straight answer.
Well, you need to call him and ask, because this case is not going to be sitting out here forever. And this is the court's problem. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. People want 200 jurors brought down, and then all of a sudden, we need a continuance. So we're going to stop this hearing. We're going to go in recess on this hearing. You're going to call him, and you're going to find out when he's going to have it done.
Yes, Your Honor. But before we stop the hearing,
No, we're going to stop it now because you need to call him and find out when it's going to be done. Because I need to know if he's going to have it done in 2 years or 3 years. We will pick this up where you left off, but that's the number one question for the court. When is it going to be done?
I will report back.
All right, thank you.
Your Honor, may I be heard on about one matter?
Yes.
Thank you, Your Honor. Additionally, this past week, we were advised that the state's chief witness has actually testified under oath, and that's what I was trying to address. The Court of Criminal Appeals, in a recent decision from last June, held that the transcript of such a testimony is discoverable as soon as is practicable. We've been asking for this kind of stuff for years.
All right,
And
so this
just-
is what I need though, Attorney Goldstein. I
Yes.
need to know when your expert is saying he's going to be done with this.
I understand, but we also need the transcript of that testimony because the Court of Criminal Appeals has been very clear. We can't be compelled to try the case if a chief witness has given prior sworn testimony
All right,
about
so
the same matter.
I
That's all.
understand what your attorney is saying, Attorney Goldstein, but what I'm telling everyone, I want to know when your expert says he is going to be done with his analysis. So that's what I need to know right now.
Thank you, Your Honor. We'll get on that. Be right back with you on the record in just a moment.
All right, thank you.
Thank you for your patience, Your Honor.
Oh, no problem.
This time we have Mr. Henderson admitting he simply gave up on his probation while facing charges for theft. The audacity here is wild.
Who is here on Nicholas Henderson? Court is calling 2022 CR 4823, State of Texas versus Nicholas Henderson. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Michael Bellable for Mr. Henderson.
And are you Nicholas Michael Henderson? Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nicholas Michael Henderson who was placed on community supervision in 2022 CR 4823 for the offense of theft of property $2,500 to $30,000 on July 5th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, we're proceeding on the supplement motion, and that's going to be violation of condition number 4 in Gibson County, Indiana. The defendant, Nicholas Michael Henderson, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, and November 2024 in violation of condition number 4.
How do you plead to that? True or not true?
It's true.
State.
We leave and abandon the remainders, Your Honor.
Any objections?
No objections, ma'am.
All right. Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you up to 2 years in the state jail facility?
Yes, ma'am.
And knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. We are asking that you grant the state's motion, adjudicate the defendant guilty and revoke his community supervision and sentence him, will reform the judgment to reflect a sentence of 1 year in the state jail.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Nicholas Michael Henderson.
All right, Mr. Henderson, why were you not reporting?
I hit a bad spot and just kind of gave up. I mean, there was no other way to put it than that. I really just kind of gave up at one point. I reported to the ICOTS officer here in San Antonio. I did report one time to the Elizabeth Greenwell, which was there in Indiana. We was on a phone contact base at one point, and I just kind of threw my hands up.
So
There's no other way to put it to you than that,
Okay.
really.
Did you complete anything?
I was paying my fines. I had started doing the cognitive thinking program. I didn't complete it, but I was going through it. I was on step 11 at that point, so I was almost there. Other than that, I was just trying to stay busy with a new career, and had a lot of good happen, but that doesn't excuse anything.
All right, probation. Does he owe restitution? All right, and does it show that he started any programs?
The MRT. He started more with Revocation there as he does.
All right, that's it?
Yeah.
All right, did you start the theft course?
I had it set up for online, but I didn't start it yet. No, ma'am.
All right, the court is going to grant the motion. Find a violation of condition number 4 true. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, good luck to you, okay?
Here's another criminal back in court, looking worse than before as he faces serious felony charges.
Hello, morning. All right. All right, each time you come back to court, you look a little bit worse. Is everything okay?
Why would I look worse?
I mean, I see more bags underneath your eyes. You just don't look the same. Is there an issue at the jail?
They don't feed you with no.
Okay. We will make sure.
I better
get a
Johnny sack then.
Hmm?
I better get a Johnny sack then.
Well, if you don't, let me know because they're supposed to feed you. All right.
Feed you enough.
Just not enough?
They don't feed you enough at all.
Okay, so what did they feed you this morning?
They feed you oatmeal with applesauce, and a little hockey puck of sausage. It's like, trust me, it's not anywhere near the food grade average you need.
All right, and what did they feed you for lunch?
Shit.
Okay, well, I mean, I'm sure they give you the same thing every day.
They feed you BS.
Yeah, so it's the bologna with the cheese. That's what I always tell people, jail, you can't order off a menu, but, all right, so where are we on this case with discovery?
Yes, Your Honor. So we have provided defense with a flash drive that holds 17 videos. I believe he was requesting 12, but there were 20 videos total. I just presented him with the CD that had one additional video. The issue we were having is that the files were corrupted, and so that's what was slowing everything down. I've sent a request for SAPD to send us those 2 corrupted videos that we are missing again, so that we can provide those to defense, but that's the status of where we are at.
All right, Ms. Ferguson, recall this case for February 18th for discovery. Right,
Thank you.
you're welcome.
Thank you.
Finally, this last case centers on Mr. West, caught damaging property and now facing criminal mischief charges.
Hello.
Hi.
Court is calling 2024 CR 011467, State versus Charles Loring Wanless. Could I have parties announced for the record? I believe that's for the court reporter. You can just sit it there.
Okay.
All right, could I have the parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Joseph Uphelt for the defense.
And are you Mr. Wanless?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
I believe I have, Your Honor, and I have reviewed it.
All right, so everyone, no talking behind the court reporter when the court is on the record. Court will find that the state is in compliance with discovery. Is there any applications in this case?
No applications, Your Honor.
All right, Mr. Wanless, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, proceeding in a lesser included criminal mischief greater than $750, but less than $2,500.
I'm sorry, you're whispering.
Proceeding on the lesser included criminal mischief greater than $750, but less than $2,500.
Any objections?
No objections, Your Honor.
All right, so off the record.
Thank
So
you.
since you all are, yes, so if you all are proceeding on that, the lesser included offense, y'all are gonna need to change this to the range of punishment, the misdemeanor range of punishment. So that he can say that he knows it. So if y'all will just put, and you can put it underneath the second paragraph.
I wasn't sure the best way to do that, Judge, but I
Oh,
thought
no,
we
no.
may have run into a
The
problem.
other,
I mean, this,
you want it on the second page?
well, if you put it on the admonishments,
On here?
yes, just so that he can be aware. And so under that first paragraph, if you'll just put the charge and then put up to 1 year in the Bear County Jail and up to a $4,000 fine. I just want to make sure that you know.
Okay.
I
the
wasn't
range
sure-
of punishment
And I
is.
wasn't sure the proper way to do it on their paperwork either.
Oh,
Judge.
no
That's why.
problem. You know, sometimes it's best to use not the state jail felony paperwork, but to use the other paperwork, and then on that line, just put
And
the
right
range of
stuff.
punishment. All right, so we're gonna go back on the record. So the state is proceeding on the lesser included offense of criminal mischief as a Class A misdemeanor. Defense, any objections?
No objection, Your Honor.
All right, so Mr. Wanless, the state is proceeding on the lesser included offense. So they're not proceeding on the state jail felony. So your range of punishment is up to 1 year in the Bear County Jail, and it's up to a $4,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he is, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Wanless, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, according to the plea, punishment is to be assessed at 199 days. Any objection to the court writing in the words Bear County Jail?
No, Your Honor.
All right, punishment is to be assessed at 199 days in the Bear County Jail. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
And we've had an opportunity to review those and have reviewed them. We have no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
With the court's permission, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Just that he has accepted responsibility for this, Your Honor. He does have 199 actual days in the Bear County Jail. We respectfully request you to follow the plea bargain, give him credit for all time served, and any time and money spent concurrent and show the judgment satisfied.
All right, the court will find you guilty. The court will sentence you to 199 days in the Bear County Jail. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because, do you understand?
Yes.
All right, so we can go off the record. Mr. Wanless, I've read the police report, so I know there are some mental health issues. Have you been on the medications at the jail?
Yes, Your Honor.
All right, so when you're released from the jail, And I'll have the court called over to the jail to make sure that you're not released at midnight, because that's usually what happens. I'm gonna see if they can release you during the day. You'll need to make sure that you set up your medications. You understand?
Sure.
So,
I'm gonna go to the Center for Healthcare Services, Your Honor.
yes. All right, make sure you do that. If for any reason something happens and you can't get in the Center for Healthcare Services, or you're lost and you don't know where to go, you can always come back here and we'll make sure that we find a place for you, okay?
Perfect, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
This is a copy for you, Mr. Wise.
Okay.
Thank you. Good luck.
Thank you.